In 2012, when the unfortunate Nirbhaya assault and murder case had happened, there was absolute public outrage at the brutality and heinousness of the crime. There was more outrage from the public, and society at large was up in arms. The reason? One of the perpetrators of the crime was a minor. So he was 17 and a half years old when he committed the crime, and hence could not be tried as an adult. Instead, he was tried under the Juvenile Justice Act. Now, under the Juvenile Justice Act, the maximum punishment given is 3 years. And when I say punishment, it is not being sent to a prison. In this case, this boy was sent to a remand home or a reform home where he was also given some vocational training. I looked this up on the net. I know he got released in 2015, and his identity remains unknown, and it is believed that he's leading a life as a cook in some part of South India and continues to remain anonymous.
That is actually pretty scary for most of us, I guess. And Sandhya, you have beautifully set the base for one of our current discussions, which is the latest car crash case in Pune, again by a minor, where two bikers died on the spot. Yeah. And unfortunately, here you see again, the boy is about 17 years and 8 months old, just about 4 months of becoming a major. So, and again, on the grounds of him being a minor, he was produced here again before the Juvenile Justice Board. And, within a couple of hours, he was released. And also he was directed to write an essay on the topic of road accidents and solutions. So it is kind of at some point of time very scary and petrifying to know how things are working. And he was also asked to work with the traffic police for about 15 days and submit a report to the board as well. So because of all these kinds of things, the public were under absolute outrage and, in fact, non-existent punishment which was given here.
Correct.
So due to the widespread protests, the boy was also arrested again and sent back to a remand home.
In both cases, the perpetrators of the crime were not majors. As we all know, the age of a major is 18. In both these cases, they were a few months short of 18 years of age. Hence, they were considered as minors and tried under the Juvenile Justice Act. Now, why is this a big challenge? Because they got relatively light punishments. In fact, they didn't get punishments, or they were not ticked off. They were just sent to reform homes. Now, this has put the spotlight firmly back on the Juvenile Justice Act, right? Because this is the act under which both the perpetrators of both the crimes sought refuge under. Now, if you look at the Juvenile Justice Act, essentially the act was put in place to deal with child offenders. In fact, when the act first got enacted in 1986, then it got amended in 2000, and the most significant amendments happened in 2015, which we are dealing with now. Initially, when the act was enacted, the phrase juvenile was used, but because there was a negative connotation to it, the 2015 Act changed it to children in conflict with law. Okay?
Right.
The object was basically to ensure that the juveniles got justice in a fair, friendly, and a quick manner, in such a way that they were not exposed to the harshness of prisons or anything. Instead, the object of the act was to correct them through counseling, through reforms, by giving them vocational training and ensuring that they get a livelihood and also some sort of an education.
Right. So, Sandhya, adding to that, I think the Nirbhaya case actually laid out a lot of public anger, first of all. And it was also obvious that the boy was minor and he committed a very hideous crime, which was like a grave rape, and it was it is a murder, right? So the logic that minor did not know of the outcoming of committing rape or murder did not at all hold good in that circumstances. And so hence the government also made an amendment to this Juvenile Justice Act in 2015, right? So when we look into that 2015 Act as such, there has been, it plugged a lot of loopholes which was there in the 2000 Act as such. So here, if you look into the Act defined as, it distinguished between the children in conflict with law, as you mentioned, and children in need of care and protection. And that amendment actually had a great change, which is the Act demarcates offenses as petty offenses, serious offenses, and heinous offenses. That was a great change which was brought to this. Yeah. So when we come to petty offenses, it is like the maximum punishment under IPC is like for 3 years, like for simple theft or robbery or forgery, which children generally, kids commit. And the other one is on the serious offenses, where the punishment was for about 3 to 7 years, where you are causing some kind of a grievous hurt. And in fact, the minimum imprisonment was not mentioned, but it is maximum is to about 7 years or more, when you're causing a grave hurt to someone. Now, when it comes to the heinous offenses, the punishment under the IPC is 7 years or more, like, for example, any kind of rape, murder, or death, or any of those circumstances, right? So I think this was the major amendment which took place in 2015.
Right. So, but the most important amendment in the 2015 Juvenile Justice Board Act is that minors aged between 16 and 18 years who have committed heinous crimes will be tried as adults in a court of law. So a couple of conditions have to be satisfied. The minor should have committed a heinous crime. If he is between 16 and 18 years of age and has committed a heinous crime, then he or she will be tried as an adult in the courts of law. Now, when I say courts of law, it's the children's court. Okay. How does this work? The process is simple. Any child in conflict, as the Act says, who's between 16, 18 and has committed a heinous crime, whether he has committed a heinous crime and whether he has to be tried as an adult will be decided by a preliminary assessment by the Juvenile Justice Board. Now, what will they assess? They will assess the physical and mental capacity, whether this child in conflict with law is actually capable of committing a heinous crime, right? And typically, the board has a time limit of usually about 4 months. It could be extendable by another 2 months. However, if it's a heinous crime, the board has to submit the assessment, complete and submit the assessment within 3 months. Now, what happens after that? If they have decided that no, he is not capable of being tried as an adult, then he will go back to be trying under the Juvenile Justice Act. If the court feels he has to be tried as an adult, his or her case will move to a children's court. Now, when I say children's court, it's those courts which actually deal with not just these cases, but also cases like relating to POCSO and everything relating to children. So what happens even in that? Now, the whole object of the Act, even then, is no death sentence or a life in prison is handed out. A few years of imprisonment or maximum with reforms will be given by the children's court as well.
So even though the 2015 Act brought in crucial changes to the law, the amendments have also been met with a lot of opposition here, especially on the aspect of reducing the age to 16 years in case of commission of any of the offense, right? So a section of the society is of the view that in future, if any child who's younger than 16 years, if they commit an offense, will that age limit be brought down further? That was the question being asked by the society. And also it is believed that treating minors as adults and putting them in company of hardcore criminals may also adverse and impact their psyche and the state of mind of the child, which is almost in conflict with the law. So this also directly defeats the objective of the enactment of the Juvenile Justice Act as such. On the other side, if you look into the statistics, also show there has been an alarming increase of offenses which have been committed by minors today. In fact, from theft to murder to cyber crimes, and in fact, even crimes on women, right?
Right.
So with the availability of internet and the exposure of unlimited information and knowledge, today minors are much more than a minor of an older generation, right? And it is today an oxymoron that today's children are more like treated like adults.
True.
So hence the laws also must factor this as well to a large extent.
True, true. Actually, dealing with the child offenders or juvenile delinquency is actually like a tightrope walk, because laws must adapt from time to time, given the changing socio-economic scenario, the tech savviness. Children in general, they are not children from, as you said, from a children of our or a previous generation. So despite the presence of laws, there could be dime a dozen laws, but what actually is the starting point will be the family. A nurturing, loving, and a kind family will almost always, you can be sure of raising a saner child. And besides that, education and awareness will ensure that a balanced child can be raised in such a way that they know or begin to understand the consequences of their actions. And hopefully, when that happens, to a larger extent, the child offenses will come down. So,
Yes.
So this is a very short discussion we had on the Juvenile Act. I hope our viewers would have gained something out of it. We'll be back with more. Thank you. Thank you.